All rise for the Honorary President and Judge of the Caribbean Court of Justice.
Between the Maya Leaders Alliance and 24 other villages and the Attorney General of Belize. The members of the panel are the Honorable Mr. Justice Anderson, President and Presiding Judge, the Honorable Madam Justice Rajnath Lee, and the Honorable Madam Justice Ononuru. Counsel, you may now enter your appearances.
Ms. Mendez, we're not hearing you.
Yes, Your Honor, apologies. May it please you? Leslie Mendez, together with Mr. Alistair Jenkins, for the appellants today before your court. I also have in person in this room with me some of the leaders that represent the various communities, and you will also see that there's another participant, Your Honor, that is projecting the room where we have current and former leaders of the various communities present here today as well.
Thank you, Ms. Mendez. I noticed you did not mention Mr. Hughes. Is he not appearing today?
I don't see him on, Your Honors.
I see.
So yes, that's why I took over the appearances, Your Honors. Thank you.
Thank you so much. Thank you.
And Your Honors, I appear together with Mrs. Samantha Matut for the respondent.
Thank you very much, Mr. Marshallek. Are there any other appearances to be entered? The Inter-American Commission on Human Rights.
Hi, listen, I'm Camila Koch, a lawyer at the Inter-American Commission on Human Rights. I'm following up with the hearing today.
Sorry, just to be clear, did you say the court or the commission?
Commission, Inter-American Commission.
Yes.
Yeah.
Thank you, ma'am. Thank you very much. Well, thank you all very much for entering those appearances. We are at a historic moment in the monitoring exercise for this case. And as we indicated on the last occasion we were together, we propose that this will be the final monitoring hearing that we conduct. Given that position, we're hoping that we could hear from the parties in terms of what has been done to implement the court's consent order issued in 2015 and provide, in a sense, closing arguments for the court so that we can perfect our record of monitoring the implementation of that order. We would proceed in the following way. We'd like to hear first from the appellants, and again, by way of closing statement, and then we'll hear from the respondent. I will then make a statement, and we will conclude the proceedings. If the authority, Professor Celario, happens to join us before my closing statement, then she would be free to also make a statement. I hope that is satisfactory to all concerned. And if it is, I would propose, therefore, that we call upon first the attorney for the appellants to make the statement on behalf of the appellants.
May it please, Your Honors. Your Honors, I think that I can give a brief overview, at least, of the participation from the perspective of the appellants in this process. But I would also like to have an opportunity, of course, to just update the court on the final submissions that have been made by the government. After that, Your Honor, I wonder if the court would allow one of the representatives of the appellant to address the court themselves for just 5 minutes, Your Honors, as I think the closing should come directly from their experience, if the court is minded, of course, to grant leave.
Yes, all of your oral applications have been accepted and granted. Please proceed.
Thank you, Your Honors. Your Honors, in terms of the implementation order, I think it is clear, and the evidence, there's overwhelming evidence as to the appellant's good faith engagement in this process. They participated from the beginning in seeking an audience before the commission as it was initially established, and it has been through their active and relentless assurance that the consent order is implemented faithful to its spirit and to its letter, that we have had some product, so to speak, of this process. I think that the dispute resolution framework, Your Honor, was one that really assisted the communities in the interim in addressing some of the encroachments in the community's pending implementation. I think that the participation of both authorities, I think, have helped us as well in the way of documenting for us not only encroachments, but very good references for the government and for all parties involved in unpacking what are the standards of especially free, prior, and informed consent. I do think that with some reservations, that the free, prior, and informed consent protocol, albeit it is, from our understanding, a working document now, has rendered some clarity in how we go about in implementing that consent process, Your Honors. We obviously expect that in the legislation, we will enhance the robustness of that process based on the lessons that we have learned now in this interim period. So certainly that has been one of, I think, again, I say with some reservation, but I think that it has helped us clarity, and it has helped us as a test case as well. And so from our perspectives, Your Honors, from the community, what has the community taken on its own? Well, the community has taken on its own a large part the delimitation of their boundaries. They have, through their own efforts and through their own labor, managed to secure funding of that process, Your Honors. And it is because they have faithfully implemented their part of that, and that they have engaged in that process and in line with the terms of the donors, that they have been able to renew the grants and the support that they have been given, Your Honor. So certainly from our perspective, we have now participated in the development of the delimitation methodologies, principles and methodology has helped us not only not only advance that process, but in fact, it is the clarity of that process that has helped us obtain those funds. So now we have 33 communities. I'm just going to check, Your Honors, because I know that there has been work. 33 communities that have consented, Your Honors, to that process. And we have 7 communities that have in fact finalized their mapping, with other communities being at various stages of that delimitation process, with numerous interboundary agreements having also been concluded between the communities. So from our end, Your Honors, the appellants have certainly participated in and contributed both in time and in money in advancing this and assisting the government in complying with this consent order. We now have a bill. We have a policy as well, a policy to which we have fundamental objections, Your Honors. We have a bill that now has hardened, as I mentioned on the last occasion, those objections. And we look forward to engaging in a consultative process. Most recently, Your Honors, we have received copies of the draft bill, the proposed roadmap, and the terms of reference of the panel. Your Honors would know that we have communicated to the government, our chosen representatives for that review panel, for quite some time. But today, Your Honor, I will say that with respect to the review panel in particular, and singularly with respect to the review panel, I do have instructions to communicate to the court that having reviewed the finalized terms of reference, Your Honors, the appellants truly would not be in a position to expend invaluable and scarce resources in a process geared towards principally ensuring compliance with the policy. Appellants, Your Honors, have consistently been clear about its fundamental objections to the policy, objections that are not minor or incidental to their rights, but they go to the core of indigenous people's rights. Your Honors, where we are right now with the review panel is precisely why we were insisting on getting or trying to settle the terms of reference of the review panel before the appellants invest time and money in that process, because we were apprehensive we would have representatives of both sides engaging in a process where there was a very different view of the nature and purpose of that review panel. I want to be clear, Your Honor, that from our perspective, the review panel was to audit the legislation's compliance with the rights of the appellants, with the consent order, and with the Constitution, not with the policy, Your Honor, not with the instructions of cabinet, because Your Honors, we consider that that is the fundamental value of the review process, not necessarily to review and to revise and ensure that there has been compliance with a policy with which it disagrees. Your Honors, in the response from my learned senior on the other side, after we had in fact shared our objections, as I understand it, the representatives from the other side take the view that there is no point in drafting a bill that will be ultimately rejected by the government. Your Honors, in our view, however, there's no point in drafting a bill that defeats the object and the purpose of the consent order and the rights recognized. That is our view. And I think that that is where really the divide lies between the parties, Your Honors. We believe that our role in this process is to ensure that there's an increase in the understanding of Maya living, Maya custom, Maya land use patterns, as well as ensuring, Your Honor, that government understands and enhances appreciation of what are the rights that need to be protected, rights that attract legal obligations, Your Honors, that they do not arise from cabinet's benevolence or its opinion, so that, Your Honor, there is limitation to cabinet consensus. That is our position, Your Honors, that we are here to ensure that the consent order is complied with. But I think at times the position is taken that we are here to do our best to contort ourselves into the cabinet's consensus. And that is not what we believe our role to be. We are here to ensure that there's compliance. And so it has always been our impression that the review panel was there to audit the legislation from that perspective, not from the perspective of ensuring that cabinet's instructions, which is fundamentally what the policy is, having not been agreed upon, are complied with. So with that, we respectfully will say that we would not be in a position to participate, that it requires an investment in resources, and more importantly, in the most valuable resource of all, Your Honor, which is time. Our position would be that we look at the roadmap again and that we go into public consultations and that the communities will be participating through that, and we will be looking at all other options, Your Honors. I will end there and just allow Christina Koch, the spokesperson for the TEA, to also address the court and just give some final remarks. Thank you, Your Honors.
Thank you.
Your Honors, thank you for the opportunity to address this court after sitting in every session of compliance hearings the last 10 years. I address you in my capacity as the spokesperson for the Toledo Alcaldes Association. This is the customary governance institution of the Maya people of Southern, who have spearheaded the legal advancements thus far for the recognition and respect of our rights to our customary lands, from which our cultural survival and our livelihood arises. In our collective and humble view, we have exhausted every legal recourse over the last 4 decades tirelessly. We have endured tremendous patience and extended the highest degree of good faith throughout this process. This is often what indigenous peoples, social justice movements are advised to do: exhaust every domestic remedy and legal recourse, seek amicable settlements between parties in the interests of peace and harmony. We have done this, Your Honors, even while enduring continued violations, a hostile political climate, and attempts to delegitimize our cause, even enduring the loss of lives and property, and finally, enduring high financial cost to legal remedy and to map our lands, even while, as Maya people, we remain Belize's poorest of the poor. When we reached the consent order in 2015, we believed that the government of Belize was acting in good faith and that this signaled a turning point. Today, 10 years later, we feel regretful to say we have not seen a different outcome, much less a meaningful one. We continue to be met with a recalcitrant government who dragged us through this long process, consistently acting in bad faith, only at the insistence of this honorable court, accepting to receive our inputs, but in the end, only to turn around and reject any considerations of our views, contributions. It demonstrates that this government does not care about Belize's indigenous peoples and is hell-bent on continuing to deny us our rights and to limit our lands, even in the face of legal judgments that affirm these very rights. We ask, where does the state stand in upholding the rule of law? How can justice systems ensure compliance? Where do we find a settlement for this long-standing conflict? We would like to place on the record that it has become clear to my people that a legal victory does not result in the acceptance of a people, their land tenure systems. It does not bring just resolution to historical wrongs or a true remedy for violations. Still, we remain steadfast, recalling as we stand on the eve of our Esant, November 1st, that our ancestors did not surrender, and neither shall we. I would like to end by extending our deepest gratitude on behalf of my people, the Maya people, to this honorable court for its time, for its efforts to endeavor to supervise the implementation of this consent order. I take this opportunity to also extend thanks to the authority, Dr. Rosa Celorio, for her enduring work to receive our complaints during this period and to honor the legacy and foresight of the late Justice Witt for carefully assisting the parties bring about this grievance mechanism. I thank each of you, Justice Anderson, Justice Rajnath Lee, Justice Sanders, Justice Ononai Wu, for your hard and enduring work to see us through this supervisory process. I also want to thank the representatives of the state for allowing me the space to speak. And on behalf of Toledo Alcaldes Association, I give you highest assurances that my people remain resolute in our defense for our rights to all of our ancestral lands. And we continue to hope for a just resolution, because without hope, there is no resistance to injustice and oppressive systems. I thank you.
Thank you, Your Honors.
Well, thank you both, and thank you particularly to the spokesperson for the Mayan people. We greatly appreciate the statement that you have made, and we greatly appreciate your representation of the Mayan people. We're also very appreciative, of course, to the other representatives who are here and who have been here throughout the hearings for the past 10 years. We are grateful for your attention to this matter, and we are also grateful for your recognition of the contribution the court has sought to make in monitoring the implementation of the consent order. Thank you very much. Respondent?
Thank you, Your Honor. Your Honors, there's little or no point in engaging in a back and forth on this any further. But suffice it to say that there are significant differences of views on matters expressed, and that is just what it is. It's not entirely unexpected. We must, however, forge forward with a potential solution to this problem. With regard to the draft legislation and the terms of reference, my friend has emphasized that the terms of reference says that the draft legislation is to be measured against the policy. That is so, but it's not the only thing the review panel is to do. It clearly also provides for the review panel to review the policy, and if it thinks that the policy should be changed, to make recommendations to change it, and if it thinks the legislation should be changed to meet the change policy, then it should make recommendations in that regard as well. All it does is where those types of recommendations are made, that they're separated in terms of the report, so that you know exactly what you're dealing with. One, measuring it against policy, and two, revisiting the policy entirely all over again and reformulating the legislation. So this is really an old dispute, one that has never been resolved, and I regret to say, one that will not be resolved with any consensus among the parties. With that said, I have been asked to deliver a prepared statement on behalf of the Attorney General and the Government of Belize, and I propose to do so now. It's not very long. It starts, Your Honor, and I hope this puts everything into context. It starts with a quote from George Cadle Price, father of the nation. It says, "Creation was not finished at the dawn of the earth, but creation continues, and we have a lot to do to make the world a better place." I think that's very true. The issues which the government has had to confront to comply with the consent order have not been easy ones. But we now have a draft of proposed legislation which sets out a scheme for recognizing and protecting Maya customary land tenure in Southern Belize for the very first time. It has required legal innovation. The first draft of this new legislation is not perfect, but it is a good faith effort to make land available to the Maya of Southern Belize, preserve their way of life, while at the same time respecting the rights of Belizeans of other ethnicities to some space within the Toledo district for the benefit of their own communities. The decade it has taken us to reach this milestone is not a reflection of any unwillingness on the part of the government to confront and attempt to resolve the Maya claims, but the fundamental difficulties involved in doing so. The government was put in the position of having to find a happy solution to a vexed land dispute between Belizean brothers and sisters. That happy solution has, not surprisingly, proven elusive. A very difficult balancing exercise has to be done. The draft legislation adopts a hybrid approach to balancing the competing interests in the same lands. It automatically recognizes core spaces for each of 41 Maya villages and reserves them for the Maya villages into perpetuity. Once recognized, this land can never again be bought or sold. These are the minimum lands within which Maya customary land tenure is to be recognized. Maya villages are free to apply for and secure recognition of the interest in additional lands, provided they can prove 30 years use and possession of those additional lands. This requirement is designed to mate this new interest in land with the existing land title regime. It does so because 30 years continuous possession is in any event enough to defeat a fee simple title given under the existing land title system. The titles of third parties, the lands in which Maya customary land tenure is so recognized, would therefore have been lost to those third-party title holders, even in accordance with existing principles. This hybrid approach, blending automatic recognition with recognition only after proof of continuous possession, provides a good model for the spaces within which Maya customary land tenure is ultimately recognized to be organically established. This overall approach can be fleshed out in any of several ways. The details presented in the draft legislation are designed to focus attention and offer a starting place for discussion and analysis. The draft now goes to a review panel comprising 4 members, 2 appointed by the appellants and 2 by the government. The review panel then presents a report making recommendations for improvement of the bill. The bill is then to be reconsidered and eventually circulated to the public for wider consultations. The government urges the review panel to see this as an opportunity not only to criticize the bill, but to offer better solutions. This is what we're after. The best possible way of sharing the finite space comprised within the Toledo district among all Belizeans, including the Maya. With that said, I wish on behalf of the Attorney General and the Government of Belize to thank this Honorable Court for its assistance and unrelenting effort over the years in bringing us to today's milestone, and to also thank all those who have worked steadfastly in furthering the process of finding a resolution to the Maya land claim for the benefit of all Belizeans. This most certainly also extends to all those who have advocated the claim on behalf of the Maya. Thank you all.
Thank you, Mr. Marshallek, and our thanks to the Attorney General also. Just to go perhaps a little over and above what I'd anticipated this morning, may I ask whether, arising from the statements made just now, the statement from the Attorney General, was it, Mr. Marshallek?
Yes, Your Honor.
Thank you. And from Mr. Marshallek's own remarks, arising from what was said, whether Ms. Mendez wishes to say anything in response, arising only from what he has said. We're not hearing you.
Apologies, Your Honor. Just as senior counsel on the other side indicated, I don't think it's necessarily helpful or desirable at all to get into a back and forth. I think with the propositions made in the policy, we have repeated them. I guess I would just simply emphasize that I would not agree that the task of the government is to find a happy solution. It is to find.
I'm sorry. I think we have heard you on that. I was simply wondering, in light of what was said by senior counsel on his own behalf and the statement read by the Attorney General, read by Mr. Marshall, whether you had any response to that. In other words, I understand the immediate sticking point to be participation on the review committee. And I was just wondering, in light of the statements made by senior counsel, whether that would cause you to reflect on that issue or not.
Honors, we have taken a careful look at the review panel, the terms of reference. We also looked at the roadmap, which represented that the terms of reference would be agreed. We have not agreed, Your Honor. The focus of it is compliance with the policy, and we maintain our position. All that I was going to indicate, Your Honor, we believe that this is about finding a principled solution, and we don't think that that is where we are geared towards right now. We will participate in the public consultations, but I thank the court for giving me an opportunity to react to what Senior has said on the other side.
You're most welcome. Thank you very much, Ms. Mendez. Happily, we have been joined by our authority, Professor Silorio. How are you, ma'am?
Thank you, Your Honor. May I speak?
Yes, you may, please.
Well, thank you so much. And I just wanted to first recognize, the important role of Your Excellencies and this court, in their monitoring capacity, but also in their role, in making sure that not only your judgments, are very important and groundbreaking when it comes to indigenous people's rights, but also that they're properly implemented. It's a lesson learned for many courts, in my humble view, of how to do monitoring in a specific case. And I just wanted to express my gratitude, not only for your work, but also for inviting me to be a part of these hearings and this process. And I also want to say a few things, about the parties. I've been involved in this process for about 6 years now. And I know that that's a very, very short time frame, considering, all the years, and all of the hard work that it has taken, to be able to advance, Maya land rights, and indigenous people's rights in Belize. And we know we're not there yet, right? This is a work in progress. This is something that continues. And I just want to salute today, the very important efforts, of both of the parties that are here, to accomplish milestones, to accomplish goals, to accomplish, protocols, to have terms of reference for a very elaborate process and a very difficult process. And my hope, right, is that, all these monitoring process, has at least helped or contributed, right, to moving, the pendulum forward, the protection of Maya land rights, in a very needed context, right, that it has contributed, towards that end. And I just wanted to say that for me, it's been a privilege and an honor to be able to be a small part of this process. I stand in admiration of all of you. I know that the work continues, right? Usually, these monitoring processes, the monitoring doesn't end here, right? But I have to say, I have to salute today, that the Caribbean Court of Justice has opened, this amazing space to be able to dialogue, to be able to find solutions, to be able to monitor, and I know that it has been a lot of hard work, not only for the court, but also for both sets of parties here. And I think in the end, we all have the same goal, to advance, Maya land rights, and to make sure, that the CCJ, consent order is properly implemented, but also all these international standards that we have, right, for the advancement of Maya land rights, and I'm hopeful. I just want to say that I'm hopeful, that we're going to be able to continue moving forward, and that goal, and thank you all to all of those that are present. I know this is a lot of hard work, but I have to say, it's been amazing to see, this process, in the last 6 years and the way it has evolved, and I do think the role of the Caribbean Court of Justice here has been fundamental, paramount, and I salute your excellencies for that, for creating a space for us to be able to be here, you know what I mean, and to dialogue about these very, very important issues. Thank you, Your Honor.
Thank you, ma'am. And I think you'd have heard earlier that all parties have expressed their appreciation of the role that you have played in the process. We're all very grateful for that. Thank you. I'm now going to ask the other members of the bench if they wish to say just one or two words about the process and the sort of historic moment we've arrived at. One of whom is my sister here with me in the court itself, Justice Rajnath Lee, who has been with us for a very long time in this process and is very experienced in the way of the developments which have unfolded in this monitoring process. The other, of course, is Justice Anoniwu, who is younger to the process, but who has been a keen observer of what has happened over the past few monitoring hearings. So I'm going to start with Justice Rajnath Lee and ask her if she wish to issue a few words, and then Justice Anoniwu. Thank you very much.
Thank you, President, and good morning again to all the parties and all the Maya people who are there. I see you in the room. When we sat in Belize in April of 2015, so many years ago, the courtroom was so packed, and our president at the time, Sir Dennis Byron, was disturbed, I can tell you that we could not accommodate every single person in the courtroom. But I do believe that many arrangements were made to accommodate everyone. That very special day, I remember it as if it were yesterday. And President, I have in my hand two very important documents. There are many others. This is a consent order entered into by the Maya Leaders Alliance and the Attorney General, and it is dated the 22nd of April 2015. And I do believe, thank you, Ms. Koch, for pointing out that order and the obligations contained in that order. I also have another very important document in my hand, the Constitution of Belize. And it is my hope that as these parties move forward, these two documents will continue to play the role that they have played. President, I wish to say I know that you will speak about the role of several of our colleagues in this process. I wish to mention in particular again Sir Dennis Byron, who was president at the time the consent order was entered into. And if I'm not wrong, it was Sir Dennis's idea that we should retain the jurisdiction to monitor. And I do believe as well that in so doing, he requested Justice Jacob Witt, our dearly departed brother, to form the first monitoring panel. I believe he was a monitoring panel of one president. And it was under his direction and with the support of the parties that the dispute resolution framework was set up. And so our brother is not with us, but I would hope that he would have been pleased despite everything and where we are today. But I believe that he would have been pleased with the progress that we have made. I also want to mention, President, our former president, President Adrian Saunders, because President Saunders came in and played a very key role in ensuring that the process continued to move forward in a way that was remarkable. And we want to express public thanks to him. President, and my own thanks to you as you took over the matter and as we have sat first with Justice Witt, I believe, then we sat with President Saunders, and then you took over, President, and our sister joined us. And we wish to say thank you to you. I wish to thank as well and to recognize the hard work of Ms. Mendez and Mr. Hughes and Mr. Jenkins, who we don't ever hear from, but who is faithful on every call. I don't think you've missed one. Thank you, Ms. Mendez. You've probably grown a lot through this process, but you've done your people proud, and I really commend you. And Mr. Marshallek, I know you had many predecessors, but thank you, because once you came on board, you seemed to be able to move the process through some, I suppose, not so easy channels. And again, Ms. Matut has always been at your side, and I wish to thank both of you for the progress that you've made. Professor Solorio, how can we ever thank you for being so willing, so transparent, so fair, so dedicated to the process? And I want to say publicly how much the court has appreciated it. I really do continue, and I hope I've thanked everybody, of course, the staff of the court. But I wish to say that I hope, Ms. Mendez, Mr. Marshallek, that despite everything that we've heard today, that there will be meaningful public consultations. Who knows, there may come out of the process the review panel as you would like to see it, but a review panel dedicated to a way forward that is in compliance with the Constitution of Belize and the terms of the consent order. So I thank you very much for this opportunity, President.
Thank you. Judge?
Thank you, President. There really isn't much I will add after hearing those wonderful remarks from my sister. I also would just want to point out how much of a privilege it has been to have joined the monitoring panel, essentially in the final year of its work. In that time, I have seen the significant efforts of all parties involved to move the process forward to a constructive resolution. I'm quite heartened, even though I understand that there are continuing differences, that we are closing the process at a point when there is under consideration policy, draft legislation, and a clear roadmap with a very, very ambitious timeline towards approval of the legislation in 2026. I really am hopeful that all parties involved will be able to work together constructively, as my sister said, towards compliance with the court's consent order, but also towards an outcome that respects the constitutional guarantees in Belize. I really have admired the efforts of the Mayan people, ably represented by their council, and also the efforts of the Government of Belize to engage constructively in this process. And I do believe that there are opportunities that exist in both the work of the review panel and the ensuing public consultation process to actively engage to ensure that the views and interests of all parties involved do result in an outcome that will inure not only to the benefit of the Mayan people, but also to the people of Belize. And so I thank you all for your active engagement in this process and look forward to seeing where this will lead. Thank you, President.
Thank you, Judge. So I'll read the following statement as from the court, which will form part of the record of these proceedings. Today we close a chapter that began 10 years ago with a 2015 judgment and consent order affirming that Maya customary land tenure is a constitutionally protected right. Since then, the Caribbean Court of Justice has retained a hands-on monitoring role, an unprecedented but powerful choice, so that the promise of the judgment would be translated into practical lived reality. That supervision ends today. Over the past decade, we required the parties to engage in periodic reporting through compliance reports and appearances at monitoring hearings. We addressed non-compliance with directions of the court, and we facilitated dialogue between the Maya communities and the Government of Belize. The court guided the parties to keep implementation on track, to map, demarcate, and secure titles, to build institutions capable of respecting customary governance, and to ensure that development decisions affecting Maya lands will be taken lawfully and with genuine consultation and participation. The ultimate goal was and remains to have subject-specific legislation enacted to protect the customary land tenure of indigenous peoples. With the adoption in January 2022 of Maya of Southern Belize Free, Prior, and Informed Consultation Protocol, the adoption in September 2025 of a working draft on recognition and protection of Maya customary land tenure in Southern Belize, along with the formulation of drafting instructions and the selection engagement of a draftsperson, and now a draft bill for the consideration of the review committee, which could be comprised of representatives from both sides of this dispute. We are of the view that the CCJ monitoring function has run its course. The 2015 judgment and consent order were delivered under the presidency of Sir Dennis Byron. The work of stewardship continued under the presidency of Justice Adrian Saunders, and now under my presidency, with the steadfast service of colleagues across changing panels. Over the years, the court's benches have included Justices Ralston Nelson, Jacob Witt, David Hayton, Maureen Rajnorth Lee, Peter Jamadar, and Chantal Onanewu. Each brought their scholarship and pragmatism to a problem that demanded both principle and patience. Permit me a special word about our late colleague, Justice Jacob Witt. He saw early and clearly that recognizing a right without building the capacity to realize it would ring hollow. He was instrumental in the establishment of the authority which addresses complaints of activities which contravene paragraph 4 of the consent order, a paragraph prohibiting any acts of the government or its agents or third parties acting without its leave, which might adversely affect the interest, enjoyment of the lands used and occupied by the Maya villages. May the closing of this chapter also stand as a tribute to his vision of providing real and practical remedies. I wish to thank the court's cohort of judicial counsel and registry staff who have ably assisted the bench in the conduct of this matter. I also acknowledge the sustained advocacy on behalf of the appellants of Ms. Antoinette Moore, Senior Counsel, as she then was, Mrs. Magali Marin Young, Senior Counsel, Mrs. Monica Magnuson, Ms. Leslie Mendez, Mr. Alistair Jenkins, and Mr. Nigel Hughes, who with their teams and the Maya Leaders Alliance and Toledo Alcaldes Association kept the human stakes at the center of the record. I also recognize the succession of attorneys general, solicitors general, and state counsel who across administrations engage with the court's directions and work to ensure the standing up of the policies and institutions required by the orders. Mr. Dennis Barrow, SC, as he then was, Ms. Naima Barrow, Mr. Nigel Hawke, Ms. Marcia Mohabibir, Ms. Elena Swift, Mr. Gerard Quesgrady, Mr. Hector Guerra, Mr. E. Andrew Marshallek, Jr., SC, and Ms. Samantha Matute. We also note with gratitude the contributions of Professor Rosa Celerio, the authority, whose expertise in international human rights and comparative practice helped illuminate the road between principle and institutional design. From beyond our region, the Inter-American Commission on Human Rights has observed this process attentively, mindful of their own jurisprudence concerning the rights of indigenous peoples. That external gaze has reminded all parties that Belize's domestic obligations sit within a wider fabric of inter-American norms and values. 10 years on, the court is satisfied that the core elements of implementation have taken root and that the supervisory role of the CCJ has achieved its purpose. Implementation will, of course, remain an ongoing task, belonging now to Belize's institutions and communities, guided by the mechanisms that have been established. The rights affirmed in 2015 are not museum pieces, but are tools for dignity, development, and peaceful coexistence. To the Maya people of Southern Belize, we take note of your consistent presence in these hearings by and through your representatives, and wish to say that your perseverance dignifies this record. To the Government of Belize, your commitment to the process across administrations is to be commended, and it is your ongoing stewardship that will measure the true success of this exercise in years to come. The court will, of course, remain of service to both sides in its regular capacity. And so, with confidence in the path ahead, the court brings its monitoring and supervisory role to a close. Our hope is that implementation of the 2015 order will proceed through its legislative and other phases in the spirit of respect, partnership, and adherence to the rule of law. Thank you all very much. If there is nothing further from counsel, nothing from the respondent,
No, Your,
nothing from the
no, Your Honor.
appellants. Thank you all very much.
No, Your Honor.
Thank you so much.
Much obliged.
Sorry, did
Thank
we hear
you.
from Mr. Jenkins a moment ago?
No, Your Honor. Thank you.
So yes, we did hear from you. Thank you very much indeed. Madam Registrar, would you please close the proceedings?
All rise.